Just let us know when to start. Okay, hey everybody, thank you for coming today to this session, Fridays at the Library, about patent and trademark searching and getting your invention to market. This is Spruce Fraser. She has come all the way from St. Louis Public Library to be with us today. She is a Patent and Trademark Resource Center librarian at St. Louis Public Library. She trains inventors on how to search for patents and trademarks, and in addition, she fields science and technology questions and teaches entrepreneurs how to write a business plan. She is the president of the Patent and Trademark Resource Center Association. She received university degrees in geography, environmental studies, and library science. And she has studied in Canada, Finland, and Germany, and speaks Finnish as well. Lots of things here. Before moving to the United States, she worked for 3 years in the Canadian Pacific Railway's Marketing Automotive Department and for Canadian Pacific Limited as a Pioneer Systems Analyst. And she is a strong believer in helping people to help themselves. Besides teaching free workshops, she does outreach to schools, business groups, and inventor associations with a range from elementary school children to inventors in the St. Louis community. Many of her customers are grassroots and trying to decide if they should invest in an attorney to apply for a patent or trademark. So she has many different skills here from the business side and from the library side, the information side, and the U.S. government legal side. Although she doesn't provide legal advice, librarians always remind people of that. So please welcome Spruce Fraser.
Thank you, Marie. Well, it's an honor to be invited to be your guest speaker this afternoon. It's a great day for a drive over the country, no clouds. And I will give you some handouts that are at the front of the classroom, as well as bookmark and business card if you're interested. You can ask for information after our talk as well. And for those who are online, you can send an email to the contact person and get more information from me as well. I look forward to explaining to you what I do as a Patent and Resource Center librarian. There are 80 of us across the country, and what I do is what the other librarians do. We help people get information as a go-between the United States Patent and Trademark Office and the public or academia. Half of us are based in libraries, public libraries, and in the other half are at academic libraries and engineering schools usually. And there's one other in Missouri, and that's in the Linda Hall Library in Kansas City. But they're in a private foundation, so that's a very bit different. I'm the one who does workshops, and I have invited guests come in. I have attorneys. I've had the FBI come in and give a talk on trade secrets. I do a lot of outreach. St. Louis has become very well known for entrepreneurs and startups. There's the Cortex, there's a venture cafe. I'm quite often allowed out to do outreach, and that's where I've been involved with mentoring new entrepreneurs as well. And again, if you have any questions, feel free to ask them, and we can just start. The purpose of this lecture is to really give you an orientation of what does the Patent and Trademark Resource Center do to help inventors and entrepreneurs. And if you have an innovation and an idea, we have people phone all the time, and then they come in, and I'll spend 1 or 2 hours with them using the website from the USPTO. We have also Advanced Pub East, which is only in St. Louis in our library and in the Linda Hall Library for Missouri. And that's what the examiners who would normally get your application for a patent, they would have that access in their place of work, whether at home or in an office. So we have permission as of a few years ago to have access to that. We have fobs, we have special passwords, so when I log people coming in who want to do advanced searches, we'll end up getting them logged in. There's also a website that I'll show you in a second, and that's just down here. This is a website that you'll see on the bookmark. There's a location to check for Patent and Trademark Resource Center information. This is set up specifically for anyone in Missouri. I have options for doing pro bono and patents and trademarks, plus how to access the United States Patent and Trademark website, which I'll look at more detail with you. This website is what we have on 2 dedicated computers in our library. You can join us. Yeah, there's still room. So these are some things that I have in our library that can help the different patrons when they come in. Okay. So now there are 3 different types of patents that people could decide to patent something. There's a plant patent, and here's a beautiful orchid, and a nice fake orchid. But this was one of the options of a patent. Now, there are thousands and thousands of plant patents. I still receive every week envelopes with plant patents and a description of them. And these plant patents are the only patents that we receive in paper. Everything else is on that website, the United States Patent and Trademark Office, uspto.gov. All the other patents, the trademark patents, design, and utility patents, those are all online. We don't receive any of them in paper anymore. That stopped in 1976. In our library, because we're one of the first 10 libraries across the United States to be a patent and trademark depository library at the time, we have all the patents that were ever published. Design patents, utility patents, we have the gazetteers, Patent Gazette that has listings of everything that was approved, and we also have the trademark, which is another source of information for people starting a business. And we have reduced the space in our library, but we have an off-site space a few blocks away, so people can still look at the original paper version. Now, the other thing that we have that's different, you have a design patent and you have a utility patent. So the first question that I ask people is, you have an idea and you want to sell a product, you want to sell a service, what are you looking for? Are you looking at a design, or are you looking at something useful? So something useful, this is a small, this way. This is a small thing that my son is working class in elementary school, but it's a design that he made for a spinning top. And you just put it on the table, pull the string. So if you wanted that as a design patent, it would be very simple. This is the picture from the front, from the back, from the top, from the bottom, from the right side, from the left side, and you don't have any explanations. Figure 1, figure 2, figure 3, and all the explanations of how this rotates around this and you pull that, that would be a utility patent. So the difference between a design and a utility patent is very straightforward. I've had one lady who came in and she had done her own patent for a design of a purse. And it was a triangular purse, and she was getting the letter. And as I get many people who are not sure what they should write back or what they should do, she went on her own to file a patent. And that's quite, that's quite a few people that I help. And what you end up doing then is following the order of what the instructions are online. You can save money usually if you're doing it online. But what you need to do is follow through what their instructions are.
We have a question, how long does a plant patent last?
Plant patents, usually they last, I believe, that's a good question that nobody's ever asked. Usually patents are good for 20 years, and that's the same thing. So there is a book that we have that's from the USPTO that gives all the details. Most of the patents are for 20 years. The only thing that's for 14 years are the design patents. Okay. And that was a very good question.
How long does the design patent last?
14 years. Mm-hmm. And we do have handouts. And again, if you're looking at this online, if you send in your mailing address, you can get these brochures that are available from the USPTO for free. I have them if you come into the library, or if you go online, all the information is online, but we have many users who don't have a computer. They might have grade 9 education. I help everybody, and I've gone to attorneys where I set up classes and I give continuing legal education credits for CLEs, and that's from the Missouri Bar Association. But I've also gone to elementary school. I'm now working with the Parkway Sparks, which is a high school program with entrepreneurs in the Parkway School District. So they have students who are wanting to become entrepreneurs. And that's where they come downtown to find out what do they need if they want to patent their idea. They're an entrepreneur it's combined together. So what we want to also mention is that when you do file, you have an application fee, and you also have a maintenance fee. Your maintenance fees will be at 3.5, 7.5, and 11.5 years. And what you need to remember is you're going to be expected to pay those. You have 6 months from that deadline to pay it. And if you don't, you've abandoned your idea. And nothing stops somebody else from taking your idea and making money and getting it made overseas. It's up to you, not the government, to sue the person if that's something you want to do. Because you've got the patent, you have the right to do it. I always say if you're working with somebody, have a disclosure agreement, even if it's your best friend from elementary school. They might come into a lot of money before you do, and run them behind your back and go file. The current situation is that to file a patent is the person who gets the patent. Several years ago, it used to be always first to invent. And we'd always say, make a notebook, write down what you do, so then you can always show, attorneys that this was my idea. You still could do that because there's a lot of patents to review to see if somebody else had your idea. And you might just take a break for a few weeks or a few months. Something happens in your family, you have that choice. But if you get a disclosure agreement set up with your friend or anybody you talk to about your idea in business, you're safeguarding that it's your idea.
So it's the first to file, get approved, who gets the patent.
Mm-hmm.
They changed that, like international law.
Well, this is United States. So this is from the United States Patent and Trademark Office.
It used to be that, instead of going international law, it used to be the first to invent.
That's right. And in 2011, they switched it over
to first to file.
First to file. And that's where I do mention, and I have a handout for that as well. There's a provisional patent, which you can use, and there's a pamphlet if you're interested. This is a provisional patent application. This is just a brochure, but the provisional will give you the option of putting a date on it. It does not say, I'm going to look at it from the USPTO and examine it. Instead, what they're doing is saying, we've received that you said it's your idea. So it's giving you a date stamp. You can say patent pending, but what you can't do, oh, it's my patent, I got it. You have to still file for a patent application. This is a provisional application for a patent. It's not a provisional patent application. So this is, if you want to do a provisional application, it's $65. It just puts a date stamp on it, and you still will have to file for a patent application. This is just giving you a year to get your idea to market. And if you don't file for a patent within that year, it's public domain. So you always should make sure, if you want to do it, you want to make sure that you're ready to do it in 12 months because the clock starts ticking. And there are no exceptions. And again, these handouts have the legal information. I'm just passing on as a go-between because I'm not an attorney. So, and one of the other things that we have is that if you are wanting to do it in a year, when you are planning to do a patent application, there is an option to do a prioritized examination where you pay $1,000. And that will give commitment from the USPTO to look at your application and examine it within 12 months. There are 600,000 to 700,000 patent applications every year. It could take 3 to 4 years before they get to yours. If you have an idea and you really want to get it to market, maybe like the high school kids at Parkway Sparks, they're in high school, they want to make some money so they can go to university and have extra money on the side. They don't want to wait a year, and the parents believe in them and they're going to give them that $1,000. So I've had some people who've come down with their parents, and they basically have gone through for a few hours with me how to do their own filing. What does it mean? What's the difference between a utility and a design? And sometimes people aren't sure what it means, and I'm not sure either because I'm not an attorney. I have a lot of connections because I do a lot of outreach, and on our board for the Inventors Association there are several attorneys who are patent attorneys. For over 20 years they've been directors there. again, I do a lot of outreach with different patent and trademark law firms as well. These are some examples of patents. It's kind of fun. There's a patent here that's for a chicken to have eye goggles. And you would think, why would somebody do that? Well, we have all kinds of interesting patents, and I have books from the Christmas patents. I have books from different Japanese, really off-the-wall type of patents, like little umbrellas that go on your head, little windshield wipers that go on your glasses. And it's a book of different Japanese things because I've been to Japan, and really, they're just so straightforward, but they're very advanced in technology. And I think that's, for a lot of people, I think it's just a marketing thing with gimmicks. And it makes a lot of money for some people. So this is my thing on, even chickens are getting henpecked.
The chicken thing, it seems like it's something that would be really obvious. Like, how can you patent, two things with a strap?
Well, there are a lot of different things like that, and obviously they did get it. So all the examiners are not necessarily attorneys, but their specialty is the field of maybe livestock, poultry, and just the idea of putting something that normally wouldn't be with something makes it something new. People have had goggles for swimming for years, but have you ever seen a chicken with goggles? My grandparents had a chicken farm. They had 16,000 chickens. I've never seen a chicken with a goggle. But somebody thought that's a possibility.
It seems like if I had chickens and I wanted to do that, I thought about doing that. It shouldn't be patented already.
Well, it is.
It seems like
somebody thought of it and decided, hey,
like it's,
it costs money to have a patent, but there are some people who just want to say, I want to have a patent. So I'm going to do it even though nobody else thinks it's something we need to patent.
Yeah, so the question is, like, you have like chickens forever, bubbles, and you put it together. So where does that whole concept of obviousness rejection coming from when that is in question?
That would be a good answer for a lawyer to give you.
Okay.
I think one of this would probably give you some good information plus a guideline to filing. And what's defined as being obvious. What the attorneys who are the official examiners, and not just attorneys, but other people who might have PhDs in chemistry and botany, they will know everything within a certain class. So they know everything and anything that's ever been patented and approved by the USPTO. So because of their knowledge and wealth, and they might have, they have supervisors, they have directors, they basically have to discuss it amongst their peers as well to see what is appropriate. But that discussion is something that's a really good point to bring up. And again, if you think it's something, or I don't think it's something, it's up to the examiner to make that decision. And they will go back and forth. If you hire an attorney, they will give the attorney their question, and then they will give it to you. And then you have to respond to your attorney, who then responds there. And usually they have 90 days to respond. So hopefully your attorney is reading their mail and making your patent application important. If you don't use an attorney, they'll directly write to you. But again, they have the same limit. And basically what you're doing with an attorney is answering questions that everybody would ask. I don't know your idea. How does it work?
Was there something about a kind of rule of thumb thing, like if it's obvious to somebody who works in the industry for which the patent is intended? Is there something like that?
I think there is, and again, there are a lot of legal words in the. If you look at the regulations, there's quite a bit involved, and to be an attorney will help you understand what they mean. But that's, what is obvious to one might not be to another, but in the field.
Mm-hmm. So is there a way for inventors to find those?
Mm-hmm. Yeah, that's what we're going to get into next. Okay. So this is just an example, and I'm just getting into Thanksgiving. We have turkey decoys, and there's actually a patent for a turkey decoy. There are several of them, and that could be pretty obvious. Like, why would a wild turkey need a decoy? Well, that's to get turkey to come to you, like a duck decoy. Excuse me. So who may apply for a patent? And according to the law, the inventor, the person whom the inventor has assigned, is under an obligation to assign the invention, may apply for a patent. And if there are two or more persons that make invention jointly, they can apply for joint inventors. However, if you only give money, then you're not considered a joint inventor. You can't be on the application. And the USPTO, the United States Patent and Trademark Office, employees cannot be having a patent either. Excuse me. Now, we've already gone through what a provisional application is for a patent. This is just to review that it's not a patent application. It provides a filing date. It provides simplified filing where the examination does not get done. You have a 12-month period. You're allowed to use patent pending for 12 months and begins the Paris Convention priority year and enables immediate commercial promotion of your invention. And this is what you can do with a provisional. One of the things that I would caution is that you have to have a corresponding non-provisional application within that year if you want to continue and get a patent. And the benefits of the provisional application cannot be claimed after the 12-month deadline. So we've gone through some of this already about the provisional application, that it's recommended that the disclosure of the invention in the application is as complete as possible because you're going to obtain the benefit of the filing date. So you can say you had your idea when you started your provisional application for a patent. And these are some more details, just telling you there's a surcharge. If you're an inventor and you've only had 4 inventions, you would have a 75% fee off when you do your patent application, and you would be called a micro-entity. Now, if you have had more than 4, but you're not a Monsanto or Emerson, you're not a big company, then you would be a small entity. And then if you're a big institution like Monsanto, you would be charged the full amount. There are fee structures on the website from the USPTO, and there are 3 columns. I'll show that to you when we get to the website. And what that tells you is the person who's just starting off gets 75% reduction. And every quarter, usually, there's an update with a date for that fee structure. It has the patent cost, the fees, and it has the trademark fees. So the trademark fees have gone down in some instances, and in the patent ones, you have that option of if you only have 1 to 4 patents, you have a reduced rate. So we have a design patent. What would this be? What do you think these are? Anybody ever ordered Scholastic books for children? This is what I ordered for my son one time. And they're shoes. You just put your feet through them. And it's before Michael Jackson had the walking shoes.
Oh, yeah.
These were moon shoes. They're not moonwalking, it's moon shoes. And it's just like sponges. So that could be a design patent, or it's actually, a utility patent. Now, there's a little label on the back that says made in China. There's probably no patent. It was made very cheap, probably for a few cents, and then just shipped through, Scholastic books. So you can have all types of patents. As my son got older, he got into rollerblading or aggressive inline skating. These are rollerblades, and all of this is a patent, but there are different parts of it that could be different patents. Here's the frames and the chocks, and then you have the wheels. They come off, and you can have these interchanged, and if they weren't so worn out, you could probably see on each one of these there's a patent number. And if you search, you can search by either the name, or you can search by, number. I'll show you a bit more of how to do that. This is what you can come up with, different designs. And you can patent those. This is your inner shoe that goes inside that. So you can change it inside. That's going to be another patent. And here's another design. And I know at one time there was one person who was selling titanium shocks and wheels, and that was to make it go faster. But you paid $300 up front before they were even produced, and they'd have so many people buy into it to get them produced that they did that. And where they did it could be overseas, it could be anywhere. So those are just some ideas. We're starting to think of winter. These I actually wore when I was little. But my guess is they're made of plastic. They're probably made in China. So or maybe at that time they were made in Taiwan. We had, this was from a local hardware store in a rural area up in Canada. So snowshoes was pretty common. And, that's an idea. You can look, if you do a search on Google Patents, you can put in keyword searches and put in snowshoe, and you'll find all kinds of designs. And I've even found some for adults that look like this, with the leather and the binding, and they say Canadian snowshoes. But there are so many different types of snowshoes, and again, how you want it to be. So that's, some ideas on what you can do for a patent. Here are some other designs. So these go way back 1915. The earliest patents that we have start in 1790, and they are all available online, except when there was a fire in the USPTO office, and those are now X patents because we don't know what they were. So if your grandmother finds patents in the attic, or you find them after she passes away, let them know if you found something, because if it has a really low number, we might not know what it is because there was a fire at the time. So, and these are just showing, not explaining what it is, it's just showing the item. What does this look like? An iPhone cover? I've had several people come by with different stands, different pocket holders, all kinds of ideas, and those can be different patents. So we've gone through what is a patent. It's anyone who invents or discovers any new and useful process. And this is what somebody asked what it could be. It's not obtained by a mere idea or suggestion. It's a complete description of the actual machine or subject matter for which a patent is required. In order for an invention to be patentable, it must be new as defined in the patent law, which provides that an invention cannot be patented if it's claimed was already patented. So, and we've gone over the fees, what's involved. And if you don't pay your fees, that's where you have 6 months to have a late fee to pay them, and then they become in public domain.
On the previous slide, very end, it says, county patented if the claimed invention was on sale. Does that mean that you can't sell your product and then patent it?
Yeah, what you do, or what you will find out, if you have posted a website and you have, gone to a trade show and you give stuff away with a brochure, the examiner will be looking everywhere to see if you have your idea out there in the public domain. If it's already in the public domain, then you won't be able to use it. So that's where you don't want to do that. You're all gung-ho, you're doing a test marketing, but if it's somewhere that they can track you down, then you won't be getting it. And what they also check, there's several websites that are available to search for patents. The SPOSnet is one that is holding about 90 million patents around the world. And there are different classifications that I'll mention in a few minutes, but they search that as well. So they'll see if anybody has a patent anywhere in the world, even though they're looking for the United States. Any other questions? Okay. Now, if some of you didn't get a Hershey Kiss, they're in the back there. But Hershey Kisses have different shapes. And I have from the USPTO this really nice display thing, it's not the only federally registered trademark associated with this candy. They have quite a few different things. So Hershey Kisses, if you search, you can find that there are other trademarks involved. And it has it for also the packaging as well. Here's the packaging and how they advertise the Hershey Kisses. We also have different types of kisses. They have caramel, peanut butter, Hershey's, still considered a trademark. And you have a little face of somebody, that's a trademark as well. When we want to switch over, I'm going to, oops. Okay. Okay. Now this is a website that I've set up that I can get involved more on how you can check to see if somebody has your idea before you start filing and spending money for an attorney or for any of the application fees. What I have done is added on this website different things like Friday Famous Inventors, different information from the USPTO that they ask the representatives to send out to the public. I have different inventions mentioned, but we also have on this website where you can go to the Inventors Association if you're in St. Louis. They have different meetings, and we've had just one every month at different locations, so this will tell you where. Our board members, you can meet who everybody is. That's if you want to know who I am. Gary is our president, and these are different attorneys. This person, Ryan, is a financial analyst, patent attorney. Yashika is somebody who I knew came for a patent, and she has desserts out of the jar. And when she wanted to patent that, she realized she'd been making money making desserts in a jar at home. She's also a mentor for the St. Louis Public Schools full-time. She started up a business with VentureWorks, got a kitchen that's licensed, hired just recently a few people to help her, and you have great desserts that you can do. And she's come to the Inventors Association and talked about that.
So I've got a question that relates to this gentleman's question. If she was already making her desserts in a jar at home in her kitchen and possibly handing them out to neighbors, would that make her idea unpatentable?
The USPTO didn't come and check with her neighbors.
Oh, so she got the patent?
Well, I don't even think she went through with the patent. She just started doing her own business.
Oh.
And that's really up to you. A lot of people have some idea, and there have been other desserts in a jar. Like when we were doing the search, or she was doing the search and I was showing her how, she started finding other things in a jar. And so her decision was, did she want to go further with it or not? Another person who was, I just got her nominated, and she's now a board member of the Inventors Association of St. Louis. Another person, she has been a teacher, she has a reading focus card, and I met her a few years ago where she gave a talk. And she had already worked through the process of having a patent for her idea. For attention deficit disorders, it was a card that has a film on it. You can change the color, and you can guide your reading so you don't get distracted by other words. And she's a teacher, so she knew that it worked. And she's gotten 2 patents on that. A program I had last April was Kids Inventing, where I had brought in several inventors. Dan Lauer, who did the water babies 25 years ago, he was a banker, and he had this great idea. So he got that started, and then 25 years later, it's still a business, and different variations. But a lot of people have ideas. They might decide to license their idea and sell it to somebody else. If you want to patent it, it's going to be your choice. If you want to patent it just by yourself, through Provisional, give yourself a year to get it going. I've seen people who have great ideas. They're retired and want to do something when they're retired and make some money so they can travel. It just depends how much money they want to invest in and how much time.
Found some information that says if you sell it or you publicly use it, you have 12 months from that day to file a provisional or file a patent.
Okay. You found that on the USPTO website?
No, I found it on IP Watchdog.
Okay, that's an attorney. If you go to my website here, all of these IP blogs are blogs all across the country that attorneys have written. And to be an attorney for patents means you've got your JD and then you're going to do an extra year for patent law. Same thing if you want to be a trademark attorney, you do an extra year to be a trademark attorney. So they have more exams to take and more experience. So
could there be a difference between public disclosure and selling? I don't know, because for papers, I mean, for academic people, that's a thing, but if you have disclosed it, I don't know if selling is, if there's a,
well, it's in the public domain when you sell something.
right, but then you.
Whether you sell it to your neighbor, like I knit scarves, but I'm not going to get a patent.
That's a deal breaker. I'm just,
Well, I know with universities, they have they have their own attorneys. We usually in the IP department will be looking at that and filing. Monsanto have their own plant attorneys. So usually it gets very specialized. One of the persons who has just retired recently knew everything about chemistry, he had a PhD in chemistry. And he, said there's so much more when you're doing research with chemical formula and you want to search to see if anybody's done that. There are certain databases that the USPTO has set up. And if somebody has questions like that, being a librarian, we have a network of 80 librarians across the country. Some have done this for 20, 30 years. Some are in the academia where they work strictly with engineers, so they have more, understanding of that. I more work with the public that have basic ideas, but again, we always have to say we're not attorneys. The laws do change, so it's always best to consider what does an attorney say. We have a network that we can also phone our Patent and Trademark Resource Center office. The program is part of the USPTO, and there's quite a few staff that we can call up anytime or send an email for questions we don't have answers to. Plus, I know several attorneys that I would ask. But they themselves don't always know because they're not an engineer. Quite a few are, but some might be botanists in different fields. So this is the IP blogs that I just have a list. And what you see on these different websites, there's a few people who, there's IP Watchdog, there's also one that is a professor here, Patently O. He's a very good speaker, and he's here at the Missouri School of Law. So if anybody here wants to check, about patent courses and intellectual property, he'd probably be one to talk to. And that's just because he's local. When we look at some other options here, the pro bono programs. The pro bono program is something that just started a few years ago from Missouri. It's done by a nonprofit, Gateway Venture Mentoring Service. I'm on the steering committee for the Patent Pro Bono program, which is through the United States Patent and Trademark Office, but a nonprofit coordinates it. People go to the website. When they file on, they'll be asked financial information, and then they'll put in their idea. First, the nonprofit will review, the administrator will review, your financial thing to see that you're not making too much money and you qualify. If you qualify, the WashU Law School, their clinic is looking at the patentability, and then the USPTO has a program where the pro bono program is for across the United States, and different universities are involved in that. In Missouri, it's different attorneys. It's from law firms. Now the pro bono trademark, so if you decide to start a business, quite often it's a good idea to start thinking of a company name. So they're connected. You get an entrepreneur who's having a great idea, but you want to start, are you going to patent a service? Are you going to patent a design? What are you going to patent? Trademarks are just as important because you need to have a name. And you can have, Hershey's Kiss. You could have a sound mark. You could have a smell as a mark. It's something that's identified to your brand, to your product, or your service. Bank of America has a wavy sign, looks like a flag, red, white, and blue. That's a service mark. Are they giving you a product? They're not giving you money, it's your money. They're giving you a service of how to invest your money or how to save your money. So there are different types of marks. There are service marks, there are sound marks, like the Roadrunner going beep beep. Okay, everybody thinks that's the Roadrunner. It's a sound mark. Disney probably has many sound marks. You can search and find out on the website. This is from the St. Louis University School of Law, Patricia Lee. She comes over and helps do our workshops that are free that we have for trademarks at the library. I have them a few times a year, and she'll come over. And people who are, again, can't afford to pay for an attorney, they get the basics when they come to the workshop or come and talk to me. I'll show them the website, and she has a program that the students in her classes each term will get different 3 or 4 trademark clients, and she'll work on that. And so, you know, anybody who comes to the workshop, they're already into the next semester. She said they're going to have space there for them. So sometimes if you come to the Patent and Trademark Resource Center, you'll get sort of a fast track as to whom to talk to. And I won't make any decisions for you. I can't make any choices for you, but I can give you the options of what you can do. Okay. Now, some of the workshops that I have, I usually post them on the website. So even though you're here in Columbia, you can come to the programs. Usually they're a Wednesday night or Tuesday night from 6 to 8. I often do some on Saturdays, and it will be all posted here usually 3-4 months in advance. I've had the United States Patent and Trademark Office come. They sent 2 people for 2 or 3 days. That was posted as well. And other things on this website, I think we've, I guess one thing I should do before we get into the thing. St. Louis, we have become really well known for startups and entrepreneurs. So if you have a great idea and you want to get help, the tech shop just started. So if you want to have an industrial sewing machine, a serger, all you have to do is pay $150 a month, and then you get trained on how to use the equipment. They have machinery, machines, they have woodworking, they have a whole new area that just opened up. I've been there a few times for tours. And again, if you have an idea, you want to get a prototype, you don't want to tell everybody about your idea, you can do it yourself. They'll train you, and it's your space. They're open till midnight, and you just can come and go as you please, and you can do your product. Now, St. Louis has a lot of other opportunities. If you're not sure whom to talk to, or you need funding, there are some other resources. Million Cups is not just in St. Louis, it's in Kansas City. Accelerate St. Louis. There's another one that just come up for entrepreneurs. They were giving, I believe, $20,000. It was just advertised yesterday. Archangels, Arch Grants, Balsa Foundation. They provide funding. Again, you have to apply, meet the criteria, and this is just an alphabetical listing. If you go to the title, you'll see who they are. They'll have an agenda, and you can decide if that's something you want to go to. So that's the header here, St. Louis Inventor Resources. It's focused on St. Louis because that's where I'm located, but Columbia is not that far away. Now, the USPTO website, I have a few computers that are dedicated to just patents and trademarks. When you start with the patents, I always suggest to go to the classification. Not so many people know about the classification. Being a librarian, I know a lot about the classification. And we have a yearly annual training seminar from the USPTO where we go to Alexandria, Virginia. And what we end up doing is having workshops and lectures from patent attorneys and trademark attorneys. And since 1790, we've had the United States Patent Classification, and there is an index that will just show how to find things right here. And what you can do is go to this index. Say, for example, I have a folding table. So I'm going to look under F. What is a folding table? It's a piece of furniture. So we're gonna just go down.
We'll do something for you.
Sure. Okay, so we're going to see a folding table, and we're going to see the number 108 and 167. This is the class, and this is the subclass. D means it's a design patent. So we're going to remember, okay, a folding table is 108 and 167. So we're going to go back, and we're going to get started. Okay, can we reduce it again?
These two, control, this is control plus.
Oh,
Control minus.
okay, that's good. Okay. We're going to search for that. 108 and 167. We're going to search here. And because it's a current classification, it's a US one, we're going to do CCL, and then 108 was the class, and 167 was a subclass. Now here we can say the years we want to search. I want to search the whole database, going back to the beginning. Now CCL means that it was just in the last 100 years or so, but we have another classification as well. Excuse me. So we're going to search this, and it's telling us that there were 130 folding table patents in that time period. And here's the list of 1 to 50 out of 130. You can go to each one to see. The ones with the lower numbers will be the oldest ones. So we go up to 130. And this is, we have over 8 million patents. So this will be the most recent one. And you click on images, full pages, and then you can just slide down and see the patent. And this is what you want to do if you want to check and see if anybody else had your idea. And as you go through this, you can see it's going to be different sections of a patent. And that's where it's written in your book what to do for a patent. And that will tell you step by step. Nolo is another book publisher that they have very good books on how to do your own designs for a patent and how to write a patent. So if you want anything further, you can go to the library and check that out. Now, if you go through the list, the title usually is not very descriptive. There's a table tennis. It doesn't say folding. Here it says just folding. So I would say you want to go through each one and check each one. So when you're doing your search, find out what class and subclass. It might be in different classes depending on how you would describe it to somebody. That's where an attorney, if you pay an attorney, he'll ask you the same information. How would you describe it? And they have paralegals probably sitting in Alexandria, Virginia. They've been doing that for several years. It's only been a few years that we've had it in our library. Hub East is what we have access to with fobs and security passwords. And St. Louis is known, you know, when I log in, there's a certain number for my fob. I have special passwords, and I have to change that every 60 days. Every library has that. That's a PTRC. So they know that somebody from my library is logging in for 2 hours, and then we have to relog them in, but there's no cost. That is what the examiner will be using from their workstation. They are 6,000 or 7,000 examiners, but they might be working from home. But they have access right into the server, and that's what we have. And it never used to be outside of Alexandria, Virginia. You would have to go there to search, and that's why you would pay an attorney, because they have people sitting there. There's like 100 cubicles, and people can sit and do work for an attorney across the country. You can come to our library and do it on your own. Mm-hmm.
I guess I just missed the connection. What's different about what you have access to versus what we have access to? Just going to the website.
The Pub East will get you into the website or into the computer server, but you can search by keyword. It also has other locations. It has the Japanese, the Eastern one, that gives you a whole lot more searching at the same time. If you wanted to search outside of the United States, you'd have to search on the SPASnet, which the examiner will do anyhow, and that has everything from around the world.
Okay,
But if you want to get,
or used, it's going to have more information about patents.
yeah, well, what you do is when you log in, well, I'll log you into PubEast. I'll show you there's keywords, how to get in. You can do Boolean searches as if you're searching like on Google, except you're getting right into the server. And what you're doing is finding out, you know, different words that you know because you know your topic better than just leaving it for somebody else. And if you go to Google search, some of the academic librarians have searched and done a comparison between the USPTO and the Google search. 75% is missing, or is there, and 25% is missing because it's scanned. They get the information and they get the original information from USPTO and put it on Google Patents. You don't get 100% of what's there. And depending on how you use the words, like one's first, one's last, we have a listserv and people are sending messages. I'm using this and I'm finding I only have 220 searches when I do it this way, but if I switch the words around, I get so many more. Or if I do this, and that's where if you go right into PubEast, you're the one who's controlling it and it's everything that's there. And you're doing a comparison to what the examiners are using. So you're actually doing what you would get if you went and paid an attorney.
Okay, thank you.
Okay.
You have another question?
Sure.
Just could you repeat the URL for the World Search website?
Okay. It's a SPASnet. If you want to. Okay. It's a worldwide search engine, and it's called a SPASnet. eSpaceNet is what it sounds like. You need to look at it. And what you're doing is coming to this website. You will get a chance to do a smart search, or you can do an advanced search, or a classification search. One of the things I was going through with the USPTO search, where I had the index and I picked up the furniture and a folding table, that worked until 2011. In the last few years, the director of the United States Patent and Trademark Office, who's now back into private practice, changed the way things were done. So for over 150 years, we were using one kind of classification system. Now there's a cooperative patent classification system. And that was dual for about 3 years. We had both systems. And now all the new patents that are classified and approved only have the CPC, Cooperative Patent Classification. It was agreed upon the United States and Europe Patent Office to have one classification, so that the United States would be the same as the world. Because we were first to file, now it's first, or we were first to invent, now it's first to file. So they've made it, in their minds, it was simpler to have one classification. However, after the first year, where we were teaching how to do a CPC search, which is different classification structure, it's more detailed. Now, the examiners, when they come on board with the USPTO, they get told to check this too. To check the USPTO, but check this too. Because Europeans have had a lot more classifications and experience with the CPC, even though it wasn't called the CPC. It's been around longer and they know more how classes can be done. So this is part of their process. So I'd always recommend go and search SPASnet to see. This has 90 million different patents. It's more the index. But if you search for something, you will find, you know, all different countries and languages. I had somebody who was asking me about, she had a specific type of shingles on her house, and it was historic in St. Louis. And there were patents on it. She had met the inventor's son. He gave all the patent numbers, and she wanted to get the patents. So she went and found me. And then I did a search for, there's a Canadian patent, Canadian patent organization as well. and there's the American one. Then there's a SPOSnet. So she found that the inventor had made some things in Mexico. We found the patents here. And then I found the Canadian ones. I went to their website. And so you can do a search and print them all out. And they're all for free. So if you're searching, you really want to be thorough, you could do that. There have been different people who I've met. There's a big thing of trying to get the Asian market in. And that's where one of the major companies here had somebody from China duplicating their product, and the product reduced their sales, so they had to cut back staff. And so what they ended up doing was hiring an Asian attorney from China who is also from the United States. Okay. So they ended up, fighting it because they had enough money to fight it. But it's not everybody who would be able to do that. It was a major company. So just wanted to let you know that those are some options that we have. Okay. So in wrapping it up, I hope that, if you have any questions, I'll be around for a bit. You can always pick up my card or come visit, send me an email. We can talk on the phone. And there's this website that's a wealth of information and should help sort of lead you through processing of what do I need to do if I want to save money, but I still want to do a patent filing with an attorney. You can do a lot of the background work yourself to see if it's justified for your, your family financial, if you want to invest in something. And what should you do? Should you do a license agreement? Should you do a provisional? Should you do something? Again, we have the option of doing trademarks. You can do trademark searches here, where it is much simpler to do a search for a trademark, where you go to tests, and when you search there, you come to this screen. So if you're still, this is an elementary thing where you want to go to find a company. If it's just a word mark, you just click on the first one. If you have a logo, or if you plan to use a logo, it will be another assignment for another $100 if you want to do it later down the road. It's easier just to get your brand together, get your design together with your word, and do it all at once. There's a design code manual that can help you out, and this can help figure out what are you going to do. It's going to be a certain place you're going to be using it. So it's very detailed. It's very interesting to look at. If you have an interest in how to get a trademark for your company, take a look at that and just get all sorts of ideas that other people have done. So I'd like to thank everybody again for coming this afternoon, and for those online. Appreciate you spending the time. And if you have questions again, I'm free to help you answer those.
Thank you.